Welcome back to the deep dive. Today we are wrestling with a Supreme Court ruling that sounds super technical, almost like legal hair splitting. But it has absolutely colossal stakes for federal sentencing. We're talking about a case that kind of redraws the lines on what counts as a crime of violence.
Right.
And it focuses on this really tricky distinction. Does failing to do something count as actively using physical force?
Yeah, it's a fascinating question.
So the legal machinery at the heart of this is 18 U.S.C. Section 924C. Now this statute, it's a major hammer in federal court.
Oh, absolutely. A big one.
If you get convicted of using or carrying a firearm during a crime of violence, boom. Automatic mandatory minimum sentence, 5 years.
And crucially, that sentence must be served consecutively. So after any other time you get.
Exactly. It's not just rolled in, it's tacked right on top.
Yeah.
Serious non-negotiable time.
And the whole thing pivots on the wording inside that statute, specifically the elements clause. That clause defines a crime of violence as a felony that, quote, has as an element the use, attempted use, or threatened use of physical force against the person or property of another.
Use, attempted use, or threatened use of physical force. Got it.
But here's the kicker. To decide if a crime, often a state crime, meets this federal definition, courts use what's called the categorical approach.
The categorical approach. I've heard of this. It's a bit strange, right?
It is, because you ignore what the defendant actually did. Totally ignore the specifics of their actions.
Really? So it doesn't matter what happened in the real world?
Not for this analysis. You only look at the law itself, the statute. What's the absolute minimum conduct someone could engage in and still be guilty under that specific law?
Okay.
And if it's possible, even theoretically, to commit that crime without using, attempting, or threatening physical force, then it doesn't count as a crime of violence for that extra federal sentence, even if the person did use force in reality.
Wow, so it's pure legal text interpretation, almost like a logic puzzle based on the law's wording.
Precisely. Statutory linguistics, not courtroom evidence.
Okay, let's ground this. Let's unpack the specific case. Delligatti v. United States. What happened there?
Right, so Salvatore Delligatti, he was convicted of attempted murder, tied into a racketeering charge, Vicar. That's violent crimes in aid of racketeering.
And the facts sound pretty bad.
They are grim. He gave a loaded revolver to some gang members, specifically so they could kill someone they thought was an informant. He was convicted for that attempted murder.
Okay, seems straightforward enough for a crime of violence charge, right? He provided the weapon for a hit?
You'd think so. But his appeal wasn't about the gun or the plot itself. His lawyers found a potential loophole. A really clever one, actually.
Based on the categorical approach.
Exactly. They looked at the underlying New York state law for attempted second-degree murder.
And what did they find?
They argued that under New York law, you could technically commit murder and therefore attempted murder by omission.
Omission, meaning not doing something.
Right, by failing to perform a legally required duty.
Okay, hang on. How does that work? Give me an example.
Well, the classic example they used, it's a tough one. Under New York law, think about a parent who has a legal duty to care for their child.
Okay.
If that parent intentionally causes the child's death by deliberately withholding food or necessary medical care, that's second-degree murder in New York.
Wow. So their failure to act, their omission, fulfills the requirement for murder.
Yes, because they had a legal duty and they intentionally breached it to cause death.
Okay, I see the argument now. So Delligatti's team said, look, because you could commit New York attempted murder by just failing to act,
then the crime doesn't categorically require the use of physical force under the federal definition.
Because how can not doing something be the use of force? Force sounds active, like hitting, pushing.
Exactly, that was the nub of it. If you cause death by omission, by, say, letting someone starve, are you using physical force, or are you just letting nature take its course, essentially? You didn't actively apply violence.
That's the million-dollar question that went up to the Supreme Court. Is intentionally causing death or injury through inaction legally the same as using physical force?
And the majority of the court landed on it.
Yes.
Yes.
They said it is the same.
They did. They affirmed Delligatti's conviction, keeping that extra 5 years on his sentence.
Okay, how did they justify that? That seems like a stretch intuitively.
Well, their conclusion was pretty broad and quite powerful. They basically said, if you knowingly or intentionally cause injury or death, it doesn't matter how you do it, act or omission. That causation itself necessarily involves the use of physical force against someone, as defined in Section 924C.
So the method doesn't matter, only the intentional result.
That's the core of their reasoning. The intentional causation is key.
Let's trace their logic. They relied heavily on precedent, right? Previous cases.
They did, especially a case called United States v. Castleman.
Castleman, okay, what did that case establish?
So Castleman was about a different law related to domestic violence, and it used a lower standard of force, basically, the force needed for common law battery, like an offensive touching.
A lower bar than the violent force needed for 924C?
Right. But Castleman set two important precedents. First, it said if you intentionally cause bodily injury, you've necessarily used the kind of force needed for battery.
Okay.
And second, critically, it said this force counts as used, even if it's applied indirectly. The example they used was tricking someone into drinking poison.
Ah, so you didn't physically pour it down their throat, but you used the poison's force.
Exactly. The perpetrator makes use of the harmful properties of the substance.
But wait, Section 924C requires violent force, not just battery-level force. How did the majority bridge that gap? That seems like a big step up.
They used another case, Stokeling v. United States, which came after Castleman. Stokeling dealt with robbery and established that even violent force can be applied indirectly. So the majority here kind of connected the dots. They said, look, if intentionally causing any bodily injury involves the use of force under the lower Castleman standard, and if violent force can be applied indirectly, like in Stokeling, then intentionally causing death or serious injury must involve the use of physical force needed for Section 924C, even if it happens through omission. The key is the intentional causation of that severe harm.
Okay, I'm trying to wrap my head around this. Deceiving someone into drinking poison feels like I'm actively using an instrument the poison, but refusing to feed someone. What am I using? My refusal. Air.
This is where the majority really hammered on the idea of causality.
Causation.
Yes. They argued, look, when a child starves because parents deliberately withhold food, their conduct, the refusal, is absolutely the cause of death. It meets the but-for test. But for the refusal, the child wouldn't have died.
Okay, causally, yes. But is causation the same as use?
The majority said yes, essentially. They then translated that causation into use with some pretty vivid analogies.
Like what?
They said, a mother who intentionally lets her child drink bleach by not intervening makes use of the bleach's poisonous qualities. Or a fugitive hiding in the dark uses the darkness by simply lying still.
Okay.
So in the omission scenario, like starvation, the argument is the person is intentionally using the natural force, starvation, disease, maybe even the cold or the tide, as their instrument. They are leveraging that force by failing to act.
So the instrument isn't a gun or a knife, it's the environment.
What?
Or a pre-existing condition.
Right.
Which the person weaponizes through inaction.
That's the logic. And they back this up by saying, look, historically, intentional murder is the classic crime of violence. When Congress wrote this law in 1986, murder and battery laws widely included liability for both acts and omissions.
How widely?
They found at least 33 states at the time defined criminal acts to include omissions where there was a legal duty. So they argued Congress must have intended to include murder by omission. Otherwise, it creates a bizarre loophole for one of the most violent crimes imaginable.
Okay, that's a powerful argument for the majority's position. But not everyone agreed. There was a dissent.
Strong dissent, yeah. Justices Gorsuch and Jackson, they basically said the majority was twisting the words of the statute completely out of shape.
What was their main point?
They used a really stark counter-analogy. The malicious lifeguard.
The lifeguard.
Yeah. Imagine a lifeguard on duty, legally obligated to save swimmers. He sees his enemy drowning. He hates this person. So he deliberately stays seated, just watches. He knows his inaction will cause death. He intends it.
Okay, shall we?
The dissent asks, did that lifeguard sitting on the sand involve the use of physical force? And their answer is a hard no, absolutely not. The text just doesn't allow for that reading.
So what's their problem with the word use, linguistically?
They argued that use means active employment. Like you employ a tool, you put something into service. They cited older cases like Bailey, saying use definitely doesn't mean inaction, inertia, or non-activity.
Action versus inaction, a fundamental difference.
Right. And they said the majority was just erasing that line. They also argue that physical force in this context means a violent physical act, not just letting, quote, pre-existing natural forces, the waves, the lack of oxygen, do the work.
So the dissent sees the waves as the force, not the lifeguard's inaction.
Exactly. They accuse the majority of confusing causation. The lifeguard's inaction caused the death with the use of force. The statute requires the latter.
And the dissent had another major criticism too, right? About mixing up different parts of the law.
Yeah, this is crucial. They said the majority was essentially blurring the lines between the elements clause, the part we've been talking about requiring force as an element, and the old residual clause.
The residual clause, that was struck down, wasn't it?
It was, years ago. The Supreme Court found it unconstitutionally vague. It used to cover crimes that involved a substantial risk of physical force being used. So the dissent basically said, look, maybe murder by omission involves a risk of force, or maybe it just seems like a bad crime we want to punish, but it doesn't have force as an element. You're trying to shoehorn these omission crimes into the elements clause, making it do the work of the defunct, vague residual clause.
They felt the majority was reaching for a desired outcome, punishing Delligatti by bending the plain text of the law.
Pretty much. And they even pushed back on the majority's use of Castleman.
How so?
They pointed out that Justice Scalia, a major figure in reading laws according to their text, specifically rejected the idea in Castleman that omissions count when a statute requires physical force. They said, sure, tricking someone with poison involves the physical force of the poison itself, but you can't stretch that logic to cover pure inaction without breaking the word use.
Okay, so let's try to summarize this deep dive into Delligatti. The Supreme Court majority essentially decided that for these federal firearm sentencing enhancements, if the underlying crime requires the intent to cause death or serious injury, it doesn't really matter how that result is achieved, whether it's an active poisoning or a passive failure to feed someone.
Right, or failing to provide medicine.
That intentional causation is now legally considered the equivalent of the use of physical force.
That's the takeaway. It's a big win for prosecutors, definitely. It makes the definition of crime of violence really broad and solidifies its application to core violent crimes like intentional murder or aggravated assault, regardless of whether the state law happens to allow for conviction by omission.
So it closes that potential loophole Delligatti's lawyers spotted.
Yeah, exactly. It stops defendants from getting out from under in Section 924C on a technicality based on the precise phrasing of the state law, especially for crimes that everyone would intuitively call violent.
Which brings us to our final thought for you, the listener. This ruling seems to really stretch the definition of using force. If the intentional failure to act like that malicious lifeguard letting someone drown by leveraging the ocean's power is now legally the use of physical force, where does that stop?
Good question.
Does this mean anytime someone intentionally fails to act when they have a duty, and harm predictably results from natural forces, think gravity, disease, cold, fire, are those natural forces now considered instruments that the person used? What does this very broad definition mean for legal duties, maybe even moral duties, outside of these extreme criminal examples?
Yeah, how far does that concept of using natural forces through inaction extend?
Something to think about, connecting this high-level legal debate back to the ideas of action, inaction, and responsibility in our own lives.